Welcome back, everybody, to the Legal Weekly Wine, where we talk about the week's hottest legal topics. And this week's hottest legal topics are the dual testimony of Donald Trump and Ivanka Trump in the civil fraud trial in New York this week. So that's our hottest legal topic. There's always something else going on, but that's pretty big. So we are going to address all of the ins and outs of what their testimony actually was that we can find, what it means, and what the implications are on appeal and for their other cases. I'm Virginia Tehrani. I am with Tehrani Law, LLC, because you never need a lawyer. Tell you do. Very good. And I am joined by co-hosts, Dr. John Weil, who is the Dean of Middle Tennessee State University's Honor College, as well as Chelsey Rogers, who is a recent attorney. Passed the bar this summer and is waiting on final, I guess,
swearing in stuff. Yeah.
The swearing in ceremony. So she just graduated from American University's Washington College of Law.
Yes, you
Did
got
I get it? Okay, good.
Is she the only one who's actually reviewed your law materials for preparation for the bar?
Yes.
Oh, yeah.
So you can claim, maybe you better stop there, 100% rate.
Truly.
100% success rate. Yes.
Yeah.
Honestly, you're not wrong.
Yeah, everybody, any law students who are listening, the Law Unscripted, which is hosting this podcast, we are also putting together law school study topics as well as bar review material that will go through the 8 core subjects of the bar exam. It will officially be published, we believe, at the very end of November. And Chelsey went through almost all of the program with me. We videotaped together for setting up the bar review classes. We had a lot of fun. Hopefully everyone else will, and we'll learn a lot and pass just like Chelsey did.
It was a good time. It's studying for the bar, but it's as much as a good time as that can be, but it was fun.
Right. We made the best of it. We did.
Absolutely.
Okay, so let's get to Donald Trump with a toast. A toast to all of the Trumps testifying and making this legal history part of our lives. I am drinking another Maryland wine, another Linganore Winecellars Mountain Red Sweet Red Wine. So that's what I am drinking today in homage to our state of Maryland. Chelsey, what have you got?
I'm joining you with the red, not quite as classy. This is my boxed Franzia chillable red wine. Surprisingly very good. I really like it.
Hey, we like good taste. So if it tastes good, then I'm all for it and we'll have to exchange here.
Yeah, it's not quite as sweet as what I normally go for. I'm trying to, expand my palate, but it's still good. It's still sweet enough for me.
Excellent. And Dr. Weil, do you have your trusty water?
I do. Purified drinking water. I don't know what brand it is. Kroger, yes, Kroger.
Okay, Kroger, local
Nothing
grocery
but
store.
Kroger.
I have a paralegal I used to work with was funny. When we got clients that were more difficult, as many attorneys have those clients, I would always know which ones they were because he would come and talk to me and he's like, I have, so-and-so. And I'd be like, oh, okay, what's going on with him? And he would look at me and he said, we get clients nothing but the best. And I was like, yeah, okay.
The way he would say it would be so perfect too. Just a complete deadpan of the face and then the lift of the eyebrows. I loved it. Delivery, fantastic.
It was great. He could be a comedian. It was good. Okay, so speaking of comedians, this clown show, it felt like what the judge Ingram, and I know I'm mispronouncing the name, so many apologies. But the judge in this trial basically said at one point, this isn't a rally, right? This isn't a party rally. You're not this isn't a stump speech. And that's how he treated it.
Right. And at another point, he turned to his attorney and said, can't you control your client?
Yes.
Yes.
Yes. So let's talk about normal courtroom behavior. Let's put Trump to the side because we're going to compare. normal courtroom behavior, I am a true trial attorney. That is what I've done for 18 years. I love trials. I love doing that. Chelsey's been a part as our intern for a long time of watching the trials, preparing for the trials, learning about trials in law school and how you're supposed to do them. And Dr. Weil has been teaching mock trial courses for a while.
25 years.
So for a couple of decades. So among the three of us, I think we've got a fairly good span as to what's expected during a trial for the questioning of witnesses, how it normally goes, and what the judge's role is, as well as the attorneys. So let's find this out. Dr. Weil, in your experience, even in preparing mock trials, how do you tell people to work with their witnesses? What are they supposed to be doing for direct examination?
Well, direct, you want them to be able to say as much as you can that's favorable to your case. You don't have to ask leading questions on direct.
And what is a leading question? Let's clarify that for everyone.
It's a question that basically suggests the answer. So, it's not, you were at 707 Main Street on such and such, weren't you? That's a leading question. Non-leading would be, where were you at such and such a time?
Okay.
But I think most of the action, came here in this case less on direct than it did on cross. Is that your understanding?
Well, it's a weird.
Or did they have cross?
They didn't.
Yeah.
This is a classic calling of an adverse witness, where the plaintiff is the New York Attorney General's office, so New York, and the defendants are the two Trump boys and Donald Trump and the trusts. Those are the defendants. And what happened is the plaintiff, as they're allowed to do, to prove their case in chief, they got to call the defendants. And they did. And the Trumps were the defendants. So it's weird because they're doing a direct examination of an adverse party. And some judges will let you treat them as a hostile witness.
Right.
And quite honestly, the behavior that Donald Trump exhibited would have been considered by many courts to be, he's a hostile witness, which is he's completely against your side and doesn't want to answer your questions. And then they have to do a direct unless the judge gives them the ability as a hostile witness to cross-examine them. But technically his own counsel would have been crossing him, and they did not do any cross-examination except of Ivanka Trump.
Right.
But there's
she
rumors.
Was a very different witness.
She was.
But partly she's not a defendant, right? If she committed fraud, it was the statute of limitations is over there.
Correct.
And she had apparently a much more winsome way. Now, what she did, and you'll know better probably than I would on this, but she did answer a lot of questions with, I don't recall or I don't remember. Mm-hmm. On the other hand, some of the things that she was asked to testify about took place 10 years ago.
Right.
And involve fairly, large financial matters, but if you handle that all the time, if you ask me what I did 10 years ago on a certain date, I wouldn't be able to tell you.
Right.
So that, whether she did know and didn't say, or whether she couldn't recall, it's not nearly as bad a strategy as, well, you're a scumbag, I'm not going to answer your question, or this is a show trial, let me out of here. You're not supposed to pontificate before a court, particularly on cross. I'm going to ask you a yes or no question. I'd like you to answer with yes or no. Now, sometimes a witness can say, well, will you give me a chance to explain?
Yes.
And sometimes sometimes they'll say yes if you keep it short or whatever. But your witness really is not supposed to be in control. Mm-hmm. They're not there to gain, points on a political poll.
Right.
They're there to testify truthfully, under oath truthfully, to matters for which they've been accused.
Right. The matters, it's limited. It's supposed to be limited to this case, this trial, these fraudulent documents and prepared papers.
So did you commit this fraudulent act? Well, let me tell you about my sainted mother. Let me tell you about my childhood. I mean, these are interesting things to me and relevant to my life, but not particularly relevant to a trial.
Chelsey, in your training, what were you taught about a normal direct or cross of a witness and how they're supposed to be handled in a court?
I love this. Yes, I love this because I took a lot of trial ad classes and I really hate doing direct, but I really love cross. And no one who's watched any of our content would be surprised because this is what they told us. When you're doing direct, your witness is the star of the show. When you are doing cross, you are the star of the show. Yes. And the way you position even down to the little things of where you position yourself in the courtroom as you're asking these questions in relation, for direct, they're like, try to stay, where you're in the same line of vision. All the attention is on the witness versus cross, where you're being like, hey, look over here. I have things to say. So that's basically how we were taught, which is why I love doing cross, because it's basically saying a sentence and saying, isn't that right? I mean, obviously.
Right? Yes.
Isn't it true that? Here's the thing I'm telling you is true. So I enjoy cross more, but this was a mess. This whole situation was a mess. And I thought you would like it, all of the relevant issues, because you always say that that's the most common objection that you deal with in trials, which was shocking to me.
Yeah, it is. And I think it is shocking to most law students because they have to go through intensive work for hearsay. These out-of-court statements made for the truth of the matter. I mean, half of evidence is spent learning hearsay rules.
And the exceptions and all of it.
Yeah, and in the end, I go and do law practice, and I was like, why am I always objecting to relevance?
403, baby.
Right? It's more prejudicial. It's irrelevant to this case. And a lot of Trump's testimony was irrelevant.
Right.
It just, I'm judging him as a witness rather than a politician, rather than a Republican. And as a witness, I would have been horrified if I were the attorney. Because I tell my witnesses, don't get angry. Right. They are trying to bait you. Whatever you do, stay calm because a jury or a judge will give you credit for that. And in this way, Ivanka Trump helped herself.
Yes.
From her testimony, Dr. Weil, like you were talking about, most newscasts are saying she was poised. She was well-spoken. She handled herself well. She didn't yell. She didn't make insults. So of all of the witnesses that were called, she seemed to be the best for both sides, quite frankly. Whereas Donald Trump, the Donald Trump Jr. and Eric Trump, they seem to be kind of witnesses, right? My great legal term here. Make sure to publish it.
Did I help pay for that tuition? What course was that?
It's what a great legal education is made of. So they were kind of wishy-washy, where their testimony from a trial attorney's perspective, it would have been maddening for them to continue to say over and over, I don't know. I don't remember. I would have been exasperated. Really, you remember nothing. I would have been tempted to start increasing my volume.
Yeah.
To start making a few sarcastic remarks. You're telling me you're the trustee of the business and you don't even know what the business is. It would have been hard.
Part of the tricky part here is you don't have a jury.
Right.
Right.
And the other thing is, it looks like the judge at the first part of the day really tried to, or before they had a couple of breaks, really tried to keep things under control.
Right.
And then, I don't know if he intended to or not, but I think the more Trump spoke, the more he opened himself up to possible later contradiction. I mean, any of us, if you speak long enough, you're going to say something infelicitous, if not, perjurous.
Yeah.
And what was sort of fascinating is there were parts where the judge would say, I'm going to strike this from the record. Well, he is the record. I mean, this is not going to a jury.
Right.
But I guess it's saying I'm not going to consider that part of the answer. I guess you're giving in some ways due notice to the other side. If you think that's coming in as evidence, I'm not even going to record it here.
Exactly.
But now what is fascinating is one of Trump's attorneys did give a subsequent press conference, and they said, how did your witness do? And he said, if I remember, it was perfect, or it was great.
It was the best I've ever had of any clients.
And he may have been paying more attention to how much he was going to get paid than he was to the truth when he said that. He wasn't under oath when he said that.
I agree. As a trial attorney, I looked at it and thought to myself, that really would be the worst possible witness I could have. Because he was out of control. He did say so many things. And like you said, Dr. Weil, the more a witness talks, whoever the witness is, the more likely something will be bad. They'll say something wrong. And Chelsey, I want you to talk about this, because in prepping witnesses for this kind of testimony, what do you normally say? What do you tell them to do?
Well, I think it's like not complex advice. This is not groundbreaking, but it's one, answer the question that's being asked and don't give any extra information. Like, you just want to answer the question that is asked, and that's it, which, clearly this is not groundbreaking advice, groundbreaking legal counsel, but that's what he needed to do and didn't. I think the New York Times had a really great quote about this. It was like, Trump on the stand was Trump anywhere else, which I think is a fair statement, is that he did not adjust for the audience or the venue to which he is speaking. It sounded like a stump speech. It sounded like he was just rambling on and on. At one point, he misquoted the years he was president. It was
that was rough.
Mess. That was a mess.
And, the compliment to that, which doesn't directly relate to this case, but if you're doing a cross-examination, you never want to almost never want to ask a question that you don't know the answer to.
Exactly.
Because you may get a lot more than you bargained for, and it may not go the way you're expecting.
Right. Yeah. He in a normal case, a witness would not be allowed to say the things that he did and to say as many things as he did. And I've seen one quote from the judge that has been misquoted many times, where it was something to the effect of, I don't want to hear you or hear from you.
Right.
And there have been a lot of people who stop at that, where they're like, well, the judge is not even listening to Donald Trump. So this is egregious. He should recuse himself. Trial should be a mistrial. But the rest of the statement was, I only want to hear your answers.
Yes.
I only want to hear the answers to the questions. So it was, I don't want to hear everything you have to say. I only want to hear the answers to the questions. That's what you're supposed to be doing. So I think it's unfair when the quote has been cut in half.
Yeah.
Because he wasn't saying, I don't want to hear from you. And he certainly was listening. And as Dr. Weil, as you said, after the breaks, he came back and just sat and listened to it all. He kind of gave up trying to control the testimony that was coming in. And honestly, I think that was the best response the judge could have had. He was being attacked left and right. Right. I mean, Donald Trump was, the judge is this, the judge is that, you're doing this, a full verbal attacks on the judge, full verbal attacks on the justice system, full verbal attacks on the plaintiff's side, the attorney general. And one of which I was very surprised in, and I would have been personally very offended, was saying about the attorney general, you should be ashamed of yourself. Right. I would never have wanted that in testimony. I would have been horrified if a witness was saying that. My witness was saying that in the trial, because in my mind, if you're saying these things, if you're railing against the other opponent, if you're railing against the other attorneys, the system, the judge, then the people in the system aren't going to look favorably on you.
No.
And they have the right to consider how you behave in the courtroom as part of their judgment of credibility of your testimony.
The problem, if I may add here, is Trump is, I think, falsely accusing the system of being politicized against him, used as a weapon against him. I don't think that's what, I mean, I think the system is trying to check on, stop illegal behavior, but I don't think this is a Democrat, Republican, liberal, conservative kind of thing. But what's very scary is the latest thing, one of the latest interviews that Trump has had
outside of the courtroom,
that if he's, if he is president again and people come after him, all he needs to do is go to the Justice Department and have them come up with a bogus indictment, and that's going to seal their fate.
Right.
If this is what our system has come to, we do not have a credible legal system. I mean, that will, I don't think it has come to that, but we cannot afford for people to, and one example of this, and I know there are a lot of different sides on this, but my understanding is when Biden came into office, who wants their son indicted, right? Who wants their son investigated?
Yeah.
And if you wanted to protect your son or daughter, you would probably seek somebody more favorable. He said, Trump appointed this guy as prosecutor. I'm not going to interfere with that.
Right.
The law is not supposed to be a handmaiden to politics. It's supposed to, search for truth. Sometimes elusive.
Yeah, and in this, I think one of the most interesting articles and quotes, I mean, I've been poring over these things because we can't watch it. And personally, I'm devastated that we can't watch it so I could really see all of it. Yeah. So we're getting pieces here and there of what people were able to see and write down. And one of the articles, I think it was in the Daily Beast, and I normally don't read that paper, but it was more of a personal opinion and just kind of like we're doing is what is our take on the system and what happened. And his comments were interesting. It was, in my experience, the extent of Trump's behavior is far outside the norm for witnesses. Ranting against the court system, prosecutors in the court during testimony would normally be considered highly unusual. And it's even more unusual that his lawyers appear to be supporting his behavior. But the most interesting, and Chelsey, you and I have talked a lot about this, so I'm going to say this as part of the article and then get your take on it.
Okay.
This article says, I've seen far less egregious behavior by a defendant result in a request that the defendant be screened for mental competency.
Yes. Okay. Yes. So my first thought was, and you can correct me, maybe it's my lack of experience. The judge's comment to me didn't seem that out of line. In full context, what he said, I was like, I feel like I've heard judges in far less contentious, like car accident cases being like, we don't need to talk about that. Can you just answer this? Like, I feel like I have heard that in really small courtrooms and really small cases. So that didn't catch me as hot. But yes, his behavior, I think if this was anyone else, they would have had a psych eval done so quick because this is not competent behavior. This is erratic. And I don't think if it wasn't Trump that he would have been allowed to, one, continue ranting and raving the way he was without some interference. And like I said, I think a psych eval would have absolutely been requested.
May I give a counter possibility that I'm not sure that I believe, but I'm going to try it.
Okay.
Could Trump, now, and it doesn't work for this case as much as it would for the criminal cases, but could he be crazy like a fox? The only thing that could keep him possibly out of jail might be being president, and he says he's not going to do it, but to try to pardon himself, which might or might not work. The Constitution is silent on it. Now, I don't think that would get him out of this civil case.
It doesn't. It doesn't excuse a civil case or a state.
Or a state case. But if his main concern is that the case down in Mar-a-Lago or the election interference cases could actually result in some kind of penalty that there'd be no way, no way out of other than to say, well, surely you're not going to put a president in jail.
Right.
Maybe there is a certain logic to it.
Mm-hmm.
And I don't know that. But
yeah, and it's certainly interesting. And he said, so apart from his behavior, let's talk about the things that he seemed to admit or deny. The statements, I mean, he said a lot, like countering the judge and the system, et cetera. But some of the actual testimony he gave, it's all testimony, but the meat of it, the real answers to the questions rather than the rambling, irrelevant information to the questions. He did admit that he was responsible for preparing the 2014 financial statement. And he did appear to admit, and this was really interesting to me, where his children, his boys both said, well, I blame it on the accountants.
Right.
It was the accountant's job, right? We prepare these statements, but they're the ones who do finances. We employ the best of the best. We rely on our accountants. We trust them. They tell us that this is what it's supposed to be. We sign off on it. So their tactic was, it's not me or dad, it's them. Trump didn't do that. He sort of did with the accountants, where he said, well, they had due diligence. They were supposed to do their own research. So whatever I put down, they were supposed to research it. And if they didn't agree, then they shouldn't have let us sign it. But then he was saying that everybody in the Trump organization, all this trust and the companies that are being run by the Trump children and then sometimes by Donald Trump when he wasn't in office, that everybody are responsible for detecting internal fraud and reporting it, correcting it. So he put it back, probably without realizing it, back on his sons who were in charge of running the organizations.
The other thing he did, Virginia, that you might want to address, because I'm a little unclear about it. The statements, apparently each statement that is filed with some kind of disclaimer.
Yes.
That you need to do your own due diligence. Now, my understanding is that really doesn't work legally as a very good defense in this case. But to someone who's not in the law, it sounds sort of credible. Well, I told you this is my guess, but you better check on it yourself.
Yeah.
So maybe you're as responsible as I am. What do you think about that defense? Because that was a partial defense.
I think it was the best defense they have, honestly. And one of the accountants has already been convicted of fraud based on these Trump statements. But for me, I look at it as this, right? Accountants have due diligence. They have fiduciary duties to their clients, in the financial sector. They have a fiduciary duty to make sure that the accounts are right, to correctly advise them, et cetera. And when they sign, think of your tax preparations, right? If you use someone to help with your taxes, they sign. You sign and they sign. But the idea that the federal government has when you're doing your taxes is, if they've prepared it, you've also looked at it. And you've signed that you agree with that. And it doesn't excuse an individual who signed their tax returns. Now, usually there's some kind of indemnification clause where the accountants will have to help defend against a lawsuit or any kind of proceedings against them for their taxes. And I think that's what they're basically saying here is like, look, we don't do numbers. They do numbers. I don't know how to calculate them. I'm not good with that. I'm good at running the business. So they take care of the numbers. And honestly, as a business owner, I feel for it because I have a bookkeeper and I don't go over all of the books every day or even every month. She tells me what's going on, if we need more money, if we are using too much money, what the state of affairs is in our business. And I'm supposed to look over it, though, as part of my ethical duties to my clients.
The one other defense that Trump makes that I think has some validity is, now it doesn't help by saying, it's not going to help you if you claim you have 30,000 square feet when you only have 10,000. Right. But he makes an argument which is almost peculiar to him. I am a brand. My name is on towers. Right. And you really can't that in and of itself has a monetary value that a typical accountant is not going to catch. Right. I think that may be as strong an argument. Again, it doesn't work with the square footage, but with some of it, it does. Trump brand is worth something right now.
Agreed. And it's hard because he was saying, you're absolutely right, he says, I think that the statements of financial condition were very good, were actually somewhat conservative, and in some cases very conservative. And in that statement and some others that he said, well, those were he agreed that some were a little too high, but then he said some were a little too low. And he's in a catch-22, because if he says that they're too high, he's admitting fraud. But if he says they're too low, he's admitting he underpaid taxes, right? So his value should have been higher and he should have paid higher taxes based on the fortune that he has. Yeah. So if we value things the way that he does, and he says that, they're very, very low, he says the judge had it at $18 million. This is at the Mar-a-Lago. The judge had it at $18 million, and it is worth, I say 50 to 100 times more than that. So I don't know how you got those numbers. He says he thinks it's between $1 billion and $1.5 billion. That's what he testified to. And the way the judge seemed to look at it was, he said at one point something to the effect of, I've already ruled that those are wrong. You should go back and look at it, or perhaps read it for the first time. So he got a little snarky with Donald Trump on that. But it's true, because the judge has already ruled that the statements were fraudulent. And for Trump to continue to testify, when you can parse through his testimony that, well, even that was wrong, it should have been higher, he's testifying that, yes, it's a fraud, and actually, I'm still trying to defraud people. This is a current fraud.
My favorite poem, Virginia. Yes.
What?
Ozymandias.
No.
Do either of you know this? So Shelley has this poem about going out into the desert, and they find this column, and it has, I am the great Ozymandias. I may be mispronouncing Ozymandias or Ozymandias. I am ruler of the world, whatever. And then the comment is, it's there in the desert sand by it. He has valued himself as this great guy, and now we don't even know who he is, other than Shelley has written a poem about him.
Oh, interesting.
So it's not, with someone with Trump's ego, it's easy to see why he might value his property much higher than other people would value it.
Right.
And not be alone in that respect.
Yeah, it is a hard valuation, but I think what the judge is trying to do in his prior opinion with the summary judgment, as well as the way that he's listening, is say, look, you can't get around some of these numbers. Like you're saying, if it's 30,000 square feet, it's 30,000 square feet, but it's not. If it's 11,000, whether you want to continue to tell me it's 30,000, whether you want to continue to tell me that Mar-a-Lago is worth more, I don't believe you. And you shouldn't be able to put these hopes and dreams into paperwork and defraud people based on it. One of the most damaging pieces of Ivanka's testimony, I think, was that she was saying, oh goodness, it was one specific deal. And they showed her an email. How they tracked down all these emails is incredible to me, because it goes back to 2011, 2012, 2013 of her doing specific dealings. And there was an email where one of the banks or an investor, I can't remember who it was saying, well, we're not willing to do this deal unless there's a guarantee that he's worth at least X amount of money.
Right.
And
$2 billion, wasn't it, or 2.5?
I think that's right.
Or you had that much, it was like liquid assets, or It was probably total value. Yes.
Right. And
she was trying to get it down.
Exactly. So she wrote to somebody else. Maybe it was Donald Trump. I can't remember. But then there was well, I'm scared to value it at this. I don't think we can because we don't seem to be worth this much money. What do we do? And there was a back and forth about, well, okay, well, now we'll value it at 1.5 or whatever it was. But to me, that's hard. I don't think that helped. I think that actually hurt the case because it was someone in charge of the company trying to make up numbers. Well, let's call it even and split the difference, split the baby and put it at 1.5. Well, why? What did you base that on? It basically sounds like you put two numbers together and then split them in the middle rather than doing an accurate valuation of this seems to be kind of loosey-goosey way to do finances than something credible and true. Now, Chelsey, what I want to ask you about is what would be the difference? Do you think the testimony for Donald Trump would have been different had this been a jury trial?
No, I don't. I think he would have been who he is. I do think the attorneys might have tried to control him more, though. I really do think that they might have tried to modulate and advise him better. I mean, I'm sure they did, but he just kind of is who he is. I think, unfortunately, or fortunately, depending on how you're looking at it, I suppose, I don't think it would have. I think he acts the same if there's a crowd or if there's an audience of one. And so he was going to do what he was going to do on that stand. But I do think if there was a jury to be influenced, the attorneys might have put more effort in trying to guide him.
I think so, too. I honestly think in most cases, the witness is not allowed to ramble and say whatever they want to say. They're usually objections, irrelevant, prejudicial.
Yeah.
The jury could be prejudiced by what he's saying that's not in response to my question. Yeah. The judges in my cases that I've had for 18 years would say, we're going to strike that testimony. Yep. You have to disregard it. I'm going to give a limiting instruction. But for a witness like this, it's my experience that a judge would admonish the witness many times. Stick to the answer because that's what the jury can hear. According to evidence rules, the jury should only be listening to the answer to the question that's relevant. Yeah. They're not allowed to make statements about the judge or the clerk or the judicial system. And if they do, they'd be either completely admonished, held in contempt, removed from the witness stand, and sometimes taken out of the courtroom. Yeah. Because if you can't control yourself, I had one, to give a small example, I had one great case early in my career where we successfully argued that the term victim shouldn't be used because we weren't sure, the defense was that we weren't sure this person was actually a victim because we didn't know if it was a crime that was committed. It was complicated, but the detective got up and testified. And 3 times he kept saying victim. Well, we talked to the victim. We did this with the victim. We met her at the hospital. And I objected each time. There's a ruling that says you can't say the word victim because it will improperly prejudice the jury into believing that there is a crime that was committed by my client. And on the 4th time that he said it in front of the jury, I will never forget the judge stood up and at the bench and he pointed his finger at the door and he said in front of the jury, I have told you 3 times already, you cannot say that word, get out and don't come back. And he was removed. Yeah. And that was just for saying one word. That was, he was told not to say. So in this case, if Trump is on the stand in front of a jury in his criminal cases, I think a judge and the attorneys would have to be much more careful because what witnesses say influence the jury. And there's always a question of, well, if you're ranting against the judge and you agree with Trump, then you will find against the whole judicial system. Yeah. And that's not allowed. So in this case, I think he actually set himself up well for the appeal. What's going to happen? We know it's going to be appealed, right? I mean,
of course.
If he's found to be, whatever damages are set against him,
now,
there
when
will
you
be an
said
appeal.
he set himself up, you mean the judge or you mean Trump?
Judge. The judge set himself up in a favorable way.
I thought that's what you meant, but it wasn't clear.
Yeah, it's hard. I did say it in a little odd phrasing, where I think he is almost guaranteeing or much more setting himself up in a good light for the appeal, where the judges will say, look, the judge gave so much consideration to this. He could have stopped the whole thing. He could have removed Trump from the stand. He could have held him in contempt, and he didn't. But the judge is still the fact finder.
Exactly.
That's the person who is going to consider and deal on your fate. Mm-hmm. I wouldn't want to be railing against the judge.
And didn't we talk to Chelsey earlier about this, that generally decisions about matters of fact are not a subject to review as matters of law. Is that correct?
On appeal.
Yes,
right,
yes, sorry.
Yes. I mean, the judge is, in fact, the finder of fact here.
Yeah. And
to the extent that they're not nearly as likely to question that as they would, was this a proper witness? Did you, that sort of thing.
Yeah, the appeal is not, we disagreed with the outcome. Let's relitigate the whole case. Right. There needs to be some abuse of discretion or blatant mistake.
Yeah, blatant misconduct, abuse of discretion, those are great keywords. On review, there's great deference paid to the finder of fact, because the appellate judges usually say, look, we weren't there. We didn't see the testimony. We weren't able to review the demeanor and the behavior and the character of the witness. We can just read a transcript. So we're going to give deference to what the finder of fact believed, who he assigned to be credible, who he decided wasn't credible. We're not going to question those decisions. We're going to question only if there was a mistake of law or if there's a blatant disregard or, problem with the facts that no one could have believed. And there was some kind of prejudice by the judge, which is what Trump will have to do. The appeal will have to stay with the judge was prejudiced against us. The entire case has to be thrown out because there was no way he was going to be a neutral party.
Right.
I think is the only appeal that would work in this case. But truly, I mean, it baffles me if you're yelling at the judge, how do you think he's going to find in your favor?
Right.
It just doesn't make any logical sense. And I have to tell another story because I've been a trial attorney, so it brings back things. I had, as a prosecutor, I had a witness, or I had a case. It was just this little bitty case of like failure to return rental property, right? He kept the leased car, the rented car. And it seemed like a nothing case, but the guy was representing himself. And I was like, oh, of all the cases I got to do, it's this one, right? We do it he wants a jury. So we do this case, and the guy was nutty. And he was grandstanding, kind of like Trump. He was grandstanding, was making large gestures. His questions and his answers were very exaggerated. It was, I'm the victim, I'm a martyr. On and on. He even held up his pants to show the jury the ankle monitor he was wearing. It was a show. It was really a show. And I told the jury at the end, we were doing closing arguments, and I was like, you're the fact finders. You get to decide who's credible. And that's based on the behaviors you've seen in court today. You can decide if you liked the defendant, and if based on what he's doing, you thought it was credible, you thought he was nice, you thought he was trying to pull a fast one. We went on of the behavior of the witness and the defendant is fair game. And not only did they come back with a verdict of guilty, but it shocked everyone when the jury gave him 1.5 years as a sentence. And everybody said, nobody gets 1.5 years for failing to return rental property. Nobody, but they hated him. They absolutely hated him. They watched his behavior. They thought he was grandstanding. They didn't like him at all. And that was the result, is he got a higher sentence than anyone I've ever heard of for failing to return rental property. So anyway, I don't think it's a very wise decision. I don't think it was a good trial tactic. Any other thoughts?
No.
The peanut gallery is very quiet today.
We have
I'm
lots of other
speechless.
trials
I'm
coming up. So
We do. We're all on edge. So this is the first, right? This is the first trial. And the first,
well, no, it's not actually.
well, that's true.
You had
You're
the
absolutely
civil. You had
right.
another civil trial.
Another corporate business one, right?
Mhm.
Then you have a sexual
Oh
harassment.
no,
Mm,
Yeah,
E. Jean Carroll.
Yes,
yes.
yes.
Chelsea,
Which
how
is
could we
going into a
forget?
second round, right?
Yes.
Yes.
With he's continuing to do what he's already been convicted of done.
Yeah.
You're absolutely right. Yeah, I think the historic. So it's not the first one. Glad you corrected us, so we're fully accurate. But it is the first time he's testified under oath at trial,
Yes.
rather than just deposition.
Right.
So to me, that is historic. I mean, to have, I think the only other president, former president, who's done testimony at a trial is Teddy Roosevelt,
Oh.
I believe.
And I was going to guess it would be Bill Clinton, but I don't know that he actually.
I don't
Had to
think
go
he
to trial.
testified.
I'm not sure.
Yeah, with the Monica Lewinsky scandal, I believe it did end up in trial. At least with some.
Well,
there was
remember,
who was
Flowers,
the lady? Yeah,
There were two other people that
Yeah.
basically one on he's making false claims here that hurt their reputation.
yeah. There was at least another woman who had recorded the call, I think, with Monica Lewinsky.
Yes.
But I think he truly is. I think Teddy Roosevelt was one. And if I remember the article, well, everybody look it up. It's a fun little sidebar is I think he was pounding his fist on the witness stand and with the gavel or whatever it was. It was quite entertaining.
He was a larger than life figure.
He was.
He's actually a little like Trump
Yeah.
in that
Yes.
it was said, and I can't remember if it was his daughter, it may have been his daughter, but he wanted to be the bride at every wedding, the corpse at every funeral, and the baby at every christening.
That's great. That's really great. Well, we've got another bombastic former president, and we're going to see where that takes him. The next part is next Monday, I believe, the 13th of November. We'll start the defense case, and I believe we're set to hear again from at least one of the Trump children, maybe more. So it will be interesting to see what their testimony is on defense versus plaintiff. But Dr. Vile, as you said earlier, they get to cross.
Yeah.
Yes.
They get another chance to question him as the plaintiffs because they get to cross-examine. So it's yet another chance to see what testimony and evidence comes out.
Let's mention also, we got at least 3 cases now. I believe one of them has been decided on a technicality. The cases that are challenging the elector schemes.
Okay.
Well, I'm sorry, the 14th Amendment case,
Yes,
Section 3.
Colorado and Minnesota. Right.
Right. But my understanding is that in Minnesota, the court has ruled that the laws of Minnesota do not permit a person to be dismissed from the ballot at this stage, that the argument has to be made later. And my other understanding is that Trump has actually made an argument, maybe in one of the other 14th Amendment cases, that what should happen is he shouldn't be excluded from the ballot, but if he were to win the election, it would then be challenged.
Oh, fascinating.
Which of course, the state is arguing very strong. They're saying, we'll talk about chaos if you let it get to the stage where he would be reelected,
and then
the court would have to come in and throw it out. That would be very problematic in terms of, what role the court should play in a democracy. So it's getting interesting. And, this is one of the few times where someone who's a scholar, now I realize the scholars were also attorneys, but, we feel that we have so little control over the world, but here 2 scholars come up with a theory that is credible enough that at least it's being litigated in 3 states, and it might actually keep a candidate off the ballot in one or more.
At least one.
Yeah.
Yeah.
So that's a pretty fascinating development.
Mm. And I know as final developments, I believe you have a couple of books of your own that have come out.
I was going to just mention, not that most of your readers are going to want to do this, but I just read a wonderful book, and it's not going to.
There you go.
That? Okay. Law and Religion in Colonial America. It's by Scott Douglas Gerber at Northern Ohio. And these are 5 colonies that he deals with in terms of, we know about the Establishment Clause and the Free Exercise Clause. And what he says, which I need to go back and revise some of my notes. Often, when we think of religion's tolerance in the United States, we track it back to John Locke, to, Rousseau or some of these philosophers. And he makes an argument that I've never seen before, but I think is correct. He doesn't actually footnote the assertion. And I have a review of this, by the way, on the First Amendment Encyclopedia online. But he says that no country in Europe adopted more laws related to restrictions on religion than did England in the 100 years or two prior to the settlement of the United States. Wow. That, because they had successions of Protestant and Catholic kings, and the Catholic king would say, we're going to go back to this, and the Protestant would say, no, we're going to go to the prayer book, and one would say you have to pledge allegiance to the king, and the other would say, well, we got the Pope in here as well. And he says that this is the background that produced Roger Williams in Connecticut, William Penn in Pennsylvania and Delaware, and then he contrasts those colonies with Connecticut and Massachusetts, where they favored freedom for fellow members of the Congregationalist Church.
Interesting.
And he also makes an interesting distinction, which I have seen before, but a distinction between the Puritans and the Pilgrims. The Puritans stayed within the Church of England, the Episcopal Church. They were trying to refine it and make it better. The Pilgrims basically were washing their hands and saying, we're going to a new land and we're going to start over.
They just left.
Yeah. So that's, and then I'm reading another book right now by Cody Cooper and Justin Dyer called The Classic and Christian Origins of American Politics. And he argues, counter to a lot of political theorists, that natural rights was not as distinct from natural law as many people think. And that particularly the early American founders, and he cites particularly John Dickinson, even Thomas Jefferson, he believes, was closer to natural law thinking in the traditional sense than he was to some of the thinking that, particularly to Hobbes. And I think he's right there, that, colonists almost uniformly, they would quote John Locke, who indicated that, yes, there was a natural law even in the state of nature, whereas for Thomas Hobbes, the only natural law was self-preservation. It really wasn't a kind of.
And Locke was the one who came up with the phrase, life, liberty, and not the pursuit of happiness, but the pursuit of property? Yeah, or the ownership of property. I don't know if he came
up with the phrase, but right. The 3 main purposes for government, as he understood it, were preservation of life, liberty, and property, all of which, he said, if you were in an anarchical state of nature, you would be unable to preserve. Your life would not be secure, your property would not be secure, nor would your liberty be.
I love that you're a scholar and we get all of these good,
well,
3-star words that you're doing.
Started reading. And this for laypersons would be an easier book.
There we go.
Democracy Awakening, Notes on the State of America by Heather Cox Richardson. I'm just getting into it, but she's basically trying to make an argument that, which I think is valid, that, if there's any core principle in America or a set of principles, it comes out of the Declaration of Independence. And, Lincoln thought that, he has one of those interesting analogies that he borrowed from the book of Proverbs, that the Constitution is the frame of silver which is meant to accent the apple of gold. And the apple of gold to him is the principle of equality and rights that's articulated in the Declaration of Independence.
Oh, all right.
But
So
I've just
good
started.
reading.
Yes.
Okay, well, thank you both for joining us. We will be back next week with the Legal Weekly Wine, and then we're hoping that the legal stories kind of pause themselves for Thanksgiving because we'd like to take a break on Thanksgiving. So the idea is that we'll have another next week, see what happens with the Trump's testimony on the defense side, and then wish everybody a happy Thanksgiving. But it's good to be with you. Have a wonderful happy hour rest of your evening and your weekend. This is Virginia Tehrani. I'm joined with Dr. John Weil and Chelsey Rogers, and this is the Legal Weekly Wine.